Hello, everyone. I'm Alex Proctor, Chief Trust and Privacy Officer at Captain Compliance. If you've seen any of my past videos or webinar talks, you may know that I spend a lot of time talking about privacy litigation risk, and I try to do that for a reason. These cases are costing companies millions of dollars every year, and frankly, they can be very frustrating for companies to deal with. Plaintiffs' attorneys have been getting very creative. They're dusting off old statutes with private rights of action, and they're using them to target companies that are running common tracking technologies on their websites. What's sort of interesting about this category of privacy litigation is that it operates almost in spite of our modern privacy frameworks. What I mean by this is that much of the online tracking activity that's being litigated would actually be considered compliant under today's state-level privacy laws. Yet, we continue to see this tension between the modern privacy statutes and the case law that's emerging from private litigation surrounding the older privacy laws. This is not a new subject here on the channel. I've already covered the California Invasion of Privacy Act, CIPA, and other state-level wiretapping laws. I've also described the Video Privacy Protection Act, or VPPA, which is a little bit different, but also being used to bring tracking lawsuits against companies. Now, in this video, I want to dedicate some time and attention to ECPA litigation. ECPA stands for the Electronic Communications Privacy Act. I'll share all the details shortly, but for now you can think of the ECPA as sort of like the federal counterpart to all of these state-level wiretapping laws like CIPA. I'm going to break down how litigators are applying the ECPA today, how courts are interpreting these cases, how the ECPA compares to the state-level wiretapping laws, and some ways in which you and your company might choose to respond to these trends. So whether you've received a demand letter alleging an ECPA violation, or if you simply want to mitigate risk proactively, this video is for you. I have two disclaimers. First, your website, analytics, and ad tech configurations all have legal implications. The tools you choose, how you deploy them, how you communicate about them, and how you manage consent surrounding them. All of these things influence your risk exposure. I'm not here to give you legal advice, but rather to share context and potential actions that you can consider taking to reduce risk. Involve your legal counsel when you make decisions about these topics. Second, if you're looking for help in this area, Captain Compliance is ready to serve as your trusted partner. Our platform offers granular consent controls, dynamic privacy notices, and automated compliance mechanisms, all of which drastically reduce exposure to website tracking-related risks. You'll find our contact details linked below if you'd like to learn more. Okay, with all that said, let's break down this law. So, what exactly is the Electronic Communications Privacy Act, or the ECPA? The ECPA is a privacy law that was enacted all the way back in 1986, long before the internet as we know it existed. The ECPA, as commonly described, actually refers to more than one law. It involves the Electronic Communications Privacy Act itself, as well as another component called the Stored Communications Act. When the ECPA was passed, it also updated the Federal Wiretap Act of 1968, and the ECPA itself has also been updated several times by more recent legislation, with one example being the Patriot Act in 2001. So, the point I'm trying to make is that there are multiple pieces of legislation that are sort of involved here under the ECPA umbrella. As a point of contrast, this is a lot more complicated than the VPPA, which, despite its own modern-day ambiguities, is actually pretty short and sweet. The main idea behind the ECPA is that it protects various forms of electronic communications while they're being made, while they're in transit, and when they are stored. There are three main titles within the ECPA, each of which deals with a different aspect of communications privacy. I'll quickly summarize all three. Title 1 of the ECPA, better known as the Wiretap Act, is the part you'll hear about most often in website tracking litigation. It prohibits the interception, use, or disclosure of any wire, oral, or electronic communication. So, In other words, the law prohibits capturing or monitoring a communication in real time unless you're legally allowed to do so. Now, there are a few important exceptions built into Title I. For example, service providers can monitor communications in the ordinary course of business when it's necessary to deliver their services. Also, as you might expect, law enforcement can perform interceptions with a court order if there's a probable cause of a listed criminal offense. There's also a key limitation within the ECPA known as the crime-tort exception. I'll tell you all about that shortly, as it's being leveraged pretty heavily in the modern tracking lawsuits. Next, Title II of the ECPA is called the Stored Communications Act, and it's focused on the privacy of data stored by third-party service providers. This can include various types of subscriber records held by a service provider. We're not going to spend much time on Title II in this video, but you should know that it exists. Finally, Title III of the ECPA deals with pen registers and trap and trace devices. If you've never heard these terms, they are a bit antiquated. Originally, they referred to physical devices, which would record dialing and routing information for calls or messages, rather than the actual content of a communication over a wire. And so, while these concepts originated with analog devices, they're being applied in new ways today. So this section of the law is still generally relevant. We do see tracking technology litigation which centers around these concepts. Still, we're going to spend more time on Title I, which is the Wiretap Act. This is simply where more claims about session replay, chat transcripts, and marketing pixels come into play. If you're interested in more on the pen registers and trap and trace side of things, my CIPA video will likely be of interest to you. In the next section, we'll look at how plaintiffs are applying the ECPA to modern web technologies and why it's creating such a complicated compliance landscape for businesses. Now that we've covered the structure of the ECPA, let's talk about how it's being used, or perhaps, depending on your perspective, weaponized in the modern day. Remember, the ECPA was written in 1986. This was a time when electronic communications meant things like telephone calls, faxes, and the very early email systems. It's probably safe and fair to say that the legislators were not envisioning the world today where nearly every website records user interactions in some way. The challenge here is obvious. Courts are being asked to apply a nearly 40-year-old law to cutting-edge web technology. That includes things like session replay scripts that record clicks and mouse movements, chat widgets that log live interactions with customer service, and tracking pixels that may be transmitting data to advertising or analytics platforms. Plaintiffs' attorneys generally argue that these tools intercept communications between users and websites, especially when data is shared with a third-party vendor in real time. Defendants, on the other hand, tend to argue that the data is first collected by the website itself as part of an ordinary course of business and otherwise doesn't qualify as an unlawful interception. Here's where we should pause and talk about one of the most notable aspects of the ECPA. This law is based on a one-party consent model. This is not always the case with wiretapping laws. Some of them require all-party consent. But with the ECPA, the statute allows an interception if one of the parties to the communication consents. So, if the company operating the website is one of those parties, and it has authorized a third-party service to process that communication, some courts have found that this fits within the one-party consent exception. Now, there's an important limitation baked into that rule, the so-called crime-tort exception. The ECPA explicitly says that one-party consent does not apply if the interception is carried out for the purpose of committing a criminal or tortious act. In other words, if a plaintiff can plausibly allege that the website or its vendor used a tracking tool to commit a privacy invasion or some underlying crime or tort, that exception can strip away the company's consent defense. This is why so many complaints frame the use of pixels and other tracking technologies as inherently unlawful or deceptive and try to fit within that exception. Now, you may be wondering, if the ECPA is a little bit harder for plaintiffs to leverage because of that one-party rule, why use it at all? There's a few reasons. First, it's a federal law, which gives plaintiffs access to federal courts and lets them bring nationwide claims. And second, it provides an avenue for class actions when other laws don't offer a private right of action. I'll explain more about that a little bit later using HIPAA as an example. Finally, even though the one-party consent rule can make these cases harder to win, the ECPA's definitions are broad and somewhat outdated, particularly when it comes to the concept of an interception. That lack of clarity gives plaintiffs just enough room to argue that tools like tracking pixels or chat widgets fall outside of the statute's safe harbors. The courts haven't always been consistent in how they interpret this law. Some have ruled that when data is transmitted directly to a third-party server or used for marketing or profiling rather than direct communications, the one-party consent rule doesn't apply. Others have dismissed similar cases, finding that the website operator's consent is enough to authorize the tracking. This inconsistency is part of the reason that we're seeing a wave of ECPA lawsuits. The outcome often depends on how a judge views the technology involved and the nature of the data flow. I also want to point out that there's a financial incentive driving this wave of litigation. Courts can award actual damages or statutory damages, the greater of $100 per day of violation or $10,000 total, plus punitive damages for willful conduct and attorney's fees. In class actions, these amounts can multiply fast. So the combination of occasionally favorable court rulings and the meaningful financial exposure makes the ECPA an appealing vehicle for plaintiffs' attorneys today. To understand how the ECPA is being tested in modern litigation, let's look at a recent case called Pattison versus Teladoc Health. This one's interesting because it involves a telehealth provider, a company that handles highly sensitive health information and the use of their web tracking tools. In this case, the plaintiffs claimed that the tracking technologies captured details about user interactions on Teladoc's website and then shared that information with third parties. The main point of focus in this lawsuit was the use of the metapixel. The plaintiffs argued that the use of this tool amounted to an unlawful interception under the ECPA. Teladoc asked the court to dismiss the case, arguing that as the operator of its own website, it was a direct party to the communication and could consent to the use of the metapixel under the ECPA's one-party consent rule. But the court didn't close the door. In June of 2025, the court largely denied Teladoc's motion to dismiss, allowing the federal wiretap claim and several state law privacy claims to move forward. The case remains ongoing. What's significant here is how the court handled the so-called crime-tort exception. This is the concept I mentioned earlier, the rule that says one-party consent doesn't apply if the interception was carried out for the purpose of committing a criminal or tortious act. In this case, the judge found that the plaintiffs had alleged enough facts to plausibly invoke that exception, not just because Teladoc collected the data, but because it allegedly disclosed or monetized sensitive information in ways that could violate privacy and consumer protection laws. This decision illustrates a key point. When plaintiffs frame these cases around the purpose of the data sharing, especially when it involves health or other sensitive data, the crime-tort exception can overcome the one-party consent defense and keep ECPA claims alive. Now that we've looked at the Teladoc case, let's step back and talk about why the healthcare industry has become such a major focus point for ECPA litigation. There's a great article by Hush Blackwell titled Healthcare Website Tracking, Lessons from 4 Recent ECPA Rulings. I'll include the link in the video description. This article highlights a growing trend. In August of 2025 alone, 4 different federal courts issued rulings involving healthcare organizations accused of violating the ECPA through the use of their website tracking technologies. These cases weren't all the same, but they all shared a common thread. Each involved a healthcare provider using analytics or advertising tools that allegedly captured user interactions on their websites. What's significant is how judges are starting to distinguish between tracking for operational purposes and tracking for marketing. When data sharing appears to be tied to advertising, it's increasingly viewed as falling outside of the ordinary course of business exception under the ECPA. That means that the simple act of embedding the metapixel or a Google Analytics tag could, in some cases, be treated as an unlawful interception of electronic communications. A big part of that concern comes from how these sorts of tracking tools can share data about page views and URLs. For example, many healthcare websites structure their URLs in a way that reveals the condition or service being viewed. What I mean by this is that you can imagine a patient landing on a web page with the words depression treatment or chemotherapy options right within the URL. If a pixel fires on that page, it can transmit the URL to a third-party platform like Meta, effectively disclosing the visitor's potential health conditions. For judges evaluating these kinds of cases, these kinds of transmissions make the marketing use feel less routine and more like a privacy invasion. The Husch-Blackwell analysis also points out that several of these cases turned on the crime-tort exception. In the healthcare context, that can mean sharing data in ways that violate privacy or consumer protection laws, including HIPAA. If you're not already aware, it's important to understand that HIPAA doesn't give individuals the right to sue. Enforcement comes from regulators. But under the ECPA, private individuals can bring their own lawsuits. So this has effectively turned the ECPA into somewhat of a stand-in for HIPAA in court, allowing patients to pursue claims that would otherwise be unavailable. The result is a sharp rise in website privacy litigation against hospitals and telehealth companies and even wellness platforms, not for traditional data breaches, but for tracking activity on websites. Courts are increasingly sympathetic to the argument that a patient visiting a healthcare website has a reasonable expectation of privacy, and that transmitting details of website interactions to third-party platforms could qualify as a wiretap. Also, while healthcare may be the most obvious example, it's not the only one. This same sort of logic could easily extend to other sectors that handle sensitive personal data, like financial services, educational platforms, or even platforms that process consumer health data. The ECPA can come into play anywhere that a website records or shares user interactions that carry an expectation of confidentiality. Now that we've explored how the ECPA is being applied in modern cases, especially in the healthcare context, it's also worth comparing it to one of the most active state laws driving similar litigation, the California Invasion of Privacy Act, or CIPA. Now, I've done an entire 40-minute long video on CIPA, and I don't want to be redundant here, so I'm just going to highlight the main differences to be aware of. On the surface, the ECPA and CIPA might seem almost interchangeable. Both deal with the interception of electronic communications. Both are being used to challenge tracking pixels and chat widgets and analytics tools. But they are absolutely applied differently, especially when it comes to consent and scope. The first is obvious if you've watched the beginning of this video. As I've been describing, the ECPA is based on a one-party consent model. As long as one of the participants in a communication, for example, the website operator, agrees to collection, an interception can be lawful. Just remember that the crime-tort exception can come into play there. CIPA, on the other hand, is an all-party consent law. In California, every party to the communication has to consent. That difference alone can make it easier for plaintiffs to bring CIPA cases. If a user never gave permission for their interactions to be recorded or shared, it's more clearly a potential violation under CIPA. No need to consider the one-party consent angle. The other major difference is jurisdiction. The ECPA is a federal statute, so it applies nationwide. This gives plaintiffs access to federal courts and allows for larger multi-state class actions. CIPA is more specific to California, and its reach can depend on where the user is located and where the alleged interception took place. Courts have wrestled with this a bit. Some rulings have limited CIPA's application to communications that have actually occurred within California. Others have allowed it to extend beyond state lines if a California resident was affected. Basically, the ECPA gives plaintiffs a federal hook and a broader reach, while CIPA may provide a cleaner path to liability, especially when a California user's communications are being tracked without clear notice or consent. Beyond those distinctions, the two statutes do share many common traits, ranging from somewhat dated statutory definitions to penalty frameworks that can multiply quickly in class action settings. In the next section, we'll look at how these two laws and others like them are starting to converge. So now that we've examined how the ECPA and CIPA differ, Let's talk about how plaintiffs' attorneys are beginning to use them together, often in the same complaint. This has become a common tactic, especially in class actions involving website tracking. By pleading both statutes side by side, plaintiffs are covering their bases more broadly. The ECPA offers the federal cause of action with nationwide reach, while CIPA adds a state-level claim with stricter consent requirements. The way that this often plays out is that a lawsuit will allege that a company intercepted communications between users and its website through session replay scripts, chat widgets, or tracking pixels. The complaint then claims that the same conduct violates both the ECPA and CIPA. This dual pleading gives plaintiffs strategic flexibility. If the one-party consent defense works under the ECPA, they can fall back on CIPA's all-party consent rule. If jurisdictional limits weaken the CIPA claim, they still have the federal ECPA claim to keep the case alive. It's a tactical overlap that can provide multiple paths forward and potentially leverage in settlement negotiations. Even if one claim is dismissed, the other can often survive. For companies, this overlap compounds risk. The same facts, say a metapixel firing on a healthcare website, can trigger both federal and state wiretap theories. Both statutes allow damages on a per violation basis. That means the financial exposure can multiply quickly when both laws are in play, especially in class action settings. We're also seeing this dual statute approach spread beyond California. Plaintiffs are pairing ECPA claims with state wiretapping laws in places like Pennsylvania, Illinois, and Massachusetts. Still, CIPA remains the most common pairing based on the pure volume of CIPA lawsuits. Now that we've talked about these ECPA lawsuit trends, let's shift to the more practical side. What can your company do to reduce the risk of ECPA litigation or even broader wiretapping litigation? One important takeaway is that most of these cases are not purely about technology. It's more accurate to think of them as being about purpose limitation, transparency, and consent. So while the use of certain tools, like the metapixel, can absolutely increase your risk exposure, companies being sued don't usually end up in that position purely because they used analytics or pixels. There's generally going to be some sort of privacy failure alongside the use of the technology. The first step here is visibility. The generalization is so true. You can't manage what you don't know. Every organization should have a clear understanding of what tracking technologies exist on their websites, as well as specifically what data they collect or transmit to third parties. Once you actually understand this, you can make so much more informed choices about which tools are operationally necessary and which might create avoidable legal risk. Your next point of focus should probably be to examine the purpose of your data processing. The ordinary course of business exception under the ECPA is pretty narrow, and courts are increasingly focused on the purpose behind tracking. So, if a tool is used to maintain basic website functionality, it may fit that exception. But when the same sort of data is a part of deep analytics or targeted marketing, that expanded purpose may influence your risk profile. Privacy notices and consent mechanisms are sort of the front line of defense here. The key to privacy notices is that they need to be thoughtfully designed and they need to be grounded in reality. If your website transmits data to third parties, especially data tied to health, financial, or other sensitive interactions, that should be disclosed clearly and prominently. Users should be able to understand in very plain language what's being collected, who receives it, and why. Consent mechanisms should also be closely evaluated. It may be obvious, but your consent technology needs to function correctly and exactly as it's being portrayed to visitors. You also need to make sure that you put thought into your default settings and whether you want to rely on an opt-out or an opt-in consent model. The safest and most privacy-conscious option is to wait for users to declare an opt-in preference before you start firing your trackers. But the reality is that this isn't always practical for companies that are heavily reliant on analytics data and online marketing capability. A final tip is to create the best documentation that you can. It's very beneficial to be able to demonstrate a deliberate compliance process. So for example, if you have documentation explaining why a pixel was deployed, the purpose that it serves, how data is handled, and how often your privacy notice and consent mechanisms are reviewed, that sort of deliberate configuration doesn't just strengthen your legal defenses, but it also demonstrates accountability and good faith when it comes to the privacy of your website visitors. To that last point, avoiding ECPA litigation really comes down to just being intentional. When companies treat tracking technologies as a key factor in their compliance program, rather than just a part of their marketing stack, these lawsuits become much less of an overarching risk. All right, that brings us to the end of our discussion on ECPA litigation. We've unpacked how the Electronic Communications Privacy Act, a law written in the 1980s, is now being applied to modern web technologies. We compared it with California's Invasion of Privacy Act, looked at how plaintiffs are combining federal and state wiretapping claims, and walked through practical ways that companies can reduce their risk exposure. If there's one key takeaway, it's probably that the ECPA is anything but obsolete, even when it comes to modern web technology. Courts are stretching its language to cover today's tracking tools. This wave of litigation isn't slowing down either. In fact, it's spreading into federal courts across the country. If your organization needs help assessing or mitigating ECPA risk, Captain Compliance is here to help. Our platform offers dynamic privacy notices, granular consent management, and automated compliance signals that help ensure that your website operates within the boundaries of both the modern privacy laws and the older statutes like the ECPA. If you need help, please feel free to reach out to me directly or visit www.captaincompliance.com. I'll include the link and our contact details in the video description below. Thanks for watching.